Good evening, everyone. Thanks so much for joining us. My name is Sarah Block, and I'm the Senior Development and Communications Manager at Brooklyn Legal Services Corporation A. I'm really happy to have you all join this evening. I hope that you're staying safe and warm. If you're actually not feeling warmth in your apartment, that will be something that you can learn about today, about your rights to heat in the apartment, what to do if you're facing landlord harassment. And so we're really excited to share this information and these materials with you all. Thank you so much to Councilmember Nurse and Councilmember Gutierrez, who have sponsored the event and have joined us this evening. We're really excited to hear from you in just a couple moments. I want to start us off with a quick overview about Brooklyn A. You may have known about us for our 55 years or be new friends, but we have been working in first in Brooklyn, in Williamsburg, Bushwick, Bed-Stuy, East New York, and Brownsville for that's where we got our start 55 years ago. Now today we work citywide. We work on three main program areas. Our work in the Preserving Affordable Housing unit works with tenants, who you'll be hearing from that program today. We work on eviction prevention, anti-harassment and fair housing claims. We work on tenant organizing, getting repairs made and essential services restored like heat and hot water, which we'll be hearing about. In our other program areas, we work with taxpayers in our low-income taxpayer clinic. If you have issues with the IRS or New York State, we can help you to resolve that. We work with homeowners that are facing foreclosure, that are victims of scams and deed theft, predatory lending. And we also work with domestic violence survivors. We can help you or someone that you know that needs those services to get an order of protection, to get child custody or support. Also help with safety planning. We have a social worker on staff in that program. And then our community and economic development program works with small businesses and nonprofits to advise small business owners on their commercial lease, helps to negotiate rent and arrears, breaches of contract, commercial tenant harassment, and we work with nonprofits on incorporation, startup services, and all the other kinds of issues that nonprofits might need some guidance on. If you or anyone that you know needs help, you can call us at 718-487-2300, or you can email us at info@bka.org. I watch that inbox, so I'll make sure that it gets to the right place. We are open Monday through Friday, 9 a.m. to 5 p.m. We have two storefront offices where you can visit us, which are located in Williamsburg and in Bed-Stuy. And also just to mention that our work with tenants is reserved just for Brooklyn tenants, though the resources that we're sharing are applicable to all tenants in New York City. And then all of our other program areas, we work citywide. So again, I want to give a huge shout out to our sponsors for this evening, Councilmember Gutierrez and Councilmember Nurse. Both have been huge supporters of Brooklyn A for several years, and do a ton of work to advocate for tenants' rights in New York City. So I want to turn it over to them to say a couple of words. So we can, Councilmember Nurse, do you want to go first?
Hi, thank you all. Good evening. Thanks, Brooklyn. Brooklyn Legal Services. Sorry, my brain is collapsing because it's been a very long day. We've been at City Hall all day. But just to everyone on the call, I hope that you know that our office is here for you. We will try our best to help support you through your housing cases and work with Brooklyn Legal Services to make sure that you are taken care of and that we try as hard as possible to keep you in your home in a safe, heated, hot watered home, in good repair. So thank you again, Brooklyn Legal Service, for all you do. And please reach out to our office if you need anything. I'll put our information in the chat. Thank you.
Thank you so much, Councilmember. We'll now hear from Councilmember Gutierrez.
Thank you, Sarah. Thank you. Hey, y'all. Thank you so much for allowing us to sponsor. I just want to uplift so much of what you said, Sarah, about, the history of Brooklyn Legal Services, Corp A. They've been truly a pillar of, yes, legal services, but also hope for so many in my district. I represent Williamsburg, Bushwick, and Ridgewood, which is in Queens. And I think, seldom run into an instance where they've told me no, that they won't represent someone because they're not in Brooklyn, or no, they won't represent someone. And so I just want to acknowledge that the level of care and compassion and advocacy that you all exhibit is really coming from a place of equity and wanting to keep people in their homes. It is the number one issue that we deal with in our office, as I'm sure is the same for Councilmember Nurse, and unfortunately for so many of us. And so to have you all in our corner, empowering residents on what their rights are, because not all of the laws are perfect, but some of them do exist. And sometimes it's just a matter of letting folks know what those laws are in the language that they can understand, so they can use that law to protect themselves and their families. And so a webinar like the one tonight is really crucial because it opens that opportunity. So I look forward to continuing to work with you all, and just thank you again for offering this option for tenants. And thank you so much.
Thank you so much. Thank you again to both of you for your ongoing support and partnership with our office, and just for all the work that you do every day standing up for tenants. We really appreciate your support. And so now I'm gonna hand it over to our presenters for this evening. Really excited to have Kevin Perry, who is a new staff attorney in the PH unit. We're really excited to have you on our team, as well as Zach Hale, who is a senior staff attorney, group representation specialist at Brooklyn A. You all are going to learn so much from them. Just wanted to make everyone aware that this presentation is live on Facebook. So if you want to go onto your Facebook and share it with your friends and family, you can do that. And we're recording it, so we'll have the recording to share after the presentation. We'll also send you a copy of the slides. So don't worry about, writing all the information down, unless that helps you to, process information. It helps me. But, we'll be sending it to you all, so you have those resources. And, again, like, this might not be issues that you're facing right now, but you never know when your friends or family are going to need these resources. So please do share widely. And I will now hand it over to Kevin.
I think Zach may actually.
Sure, I'll hop on. I'll get things going, and then I'll
okay.
pass it off to Kevin. How's that?
All right, yeah, let's do that. So yeah, Zach, you take it.
Yeah, because we added we wanted to talk specifically with everybody that is able to be on this call or watch the recording about your rights during heat season, because I don't know if you've been outside today, but it's pretty chilly, and we've dipped down, I think, pretty officially into the winter weather. So on our first slide, we'll see the next slide, just some specifics about what heat season is. You'll know, many of you will know already that starting in October, on October 1st, your landlord, if you live in a building that has a centralized heat system, so that will be, you know, most buildings that are, you know, before the 70s built, even some new buildings, but when they have a radiator or steam heat like that, in those buildings, once you hit October 1st, your landlord has a responsibility to provide the heat to a certain level. It can be a little bit confusing to know whether, because sometimes it feels cold inside, but it's technically still above the threshold. So that's why it's important to note the time of day matters. You know, so for those of you that can see the slide, between 6 a.m. and 10 p.m., it's got to be at least 68 degrees inside when it's below 55 degrees outside. Okay, so if you are able to look at, you know, weather on your phone or something like that, and you see that it's 54 degrees outside, then your apartment during the daytime should be up at 68 degrees. And then between 10 p.m. and 6 a.m., so overnight, that temperature is allowed to go down to about 62 degrees. So that can still feel pretty chilly. But the basic rule there is that, you know, your heat should be on, you know, and so, you know, whether your heat is on or not. You probably have dealt with, you know, sometimes wondering whether it's on and touching, you know, don't touch the radiator when it gets too hot. But, you know, if for some reason it's not on, when you know that it's cold outside, you're feeling cold, but you don't have, you know, a thermometer or a way to check the temperature in your apartment or in your room, you can just reach out. If you have a phone number for your management, reach out to your landlord and let them know. I mean, don't hesitate to let them know. Now, you know, for many people that we work with at Brooklyn A, this is a pattern, right? That happens every winter, and their landlord knows it's off. And so in that situation, you know, you might want to move straight to calling 311. So 311, again, many of you are already familiar. It's a central hotline, but it can get you in touch with HPD to have an HPD inspector come and check on your heat. Now, HPD doesn't come right away usually, and they let the landlord know before they come. So frequently, if it's a landlord that has the power to turn on the heat, when they get that notification that HPD is coming, then they may turn on the heat at that point. If it's a landlord who is using heat as a tool of harassment, which we will talk about shortly, in that case, then they may turn it off again after the HPD visit. So that's something to look out for. The best way to deal with this, and we can go to the next slide, is take records, right? So actually, you know, I recommend this with everything. We'll talk about it with harassment, but heat is a difficult thing to record because it's like a feeling, right? It's not something you see. So if you're able to go down and get, just for a few bucks, you can usually get a thermometer. They'll have them at a lot of just kind of basic hardware stores. Get like an air temperature thermometer. Then you're able to actually, you know, see the temperature to know if it's the right temperature, and then you can take a picture of it, or you can keep a log, and in the log it should say the time and what the temperature was. And that way, if you do need to go to court, which hopefully you don't, then you have a record that you can refer to. And you know, hopefully many landlords just, it's an old boiler or something, and early in the winter when it kicks on, it might have some bugs, some issues with it. So hopefully it's the type of thing they can fix and it stays fixed. It does occasionally become a bigger issue. You want to talk to your neighbors about this and all kinds of issues in your building, because you're going to, if you're experiencing it, especially on a common heat system, they are probably experiencing it too. So you all can work together, let the landlord know together, If the landlord is using it as a tool of harassment, we'll talk about that here in just a second, but you might end up needing to file a complaint or go to court. And what I'll say, the last thing about the heat itself, heat and hot water, if you're a rent stabilized or rent controlled tenant, then you can file a complaint with DHCR, the Department of Housing Community Renewal. You can just on your phone or online search DHCR heat complaint. They have a very easy online version of it, and they will be able to send an inspector. It usually takes some time, but if they see that there's no heat, they will reduce your rent to the previous level, and it will stay there until they can see that the heat is fixed. So that can help you, because you shouldn't be paying full rent when you don't have heat. It's not right. So we'll go to the next slide. So this connects with the overall issues of harassment. So within heat is one tool of harassment, but landlords can do many things that are harassing to tenants. Unfortunately, this is very common across New York City. It is not just what you think of as harassment, though, right? So it's not just like what you would say to your friend, oh, so-and-so is harassing me, right? I know that's a little bit, it can be strange, but there's a specific legal definition that comes into play when it deals with landlord-tenant law. So I wrote the legal definition here on the slide. I'll read it out loud. Harassment is any act or omission by or on behalf of an owner that causes or is intended to cause a tenant to surrender or waive any rights in relation to the occupancy of their unit. Now, what does that mean? A bunch of legalese. Basically, if the landlord is taking any action, but really they have a list of actions that the housing court considers most serious, with the intention of causing you to leave your apartment, basically. So it's different than criminal harassment. There's like, if you were to go to the police with a police report on harassment, that's a totally different law. And even the criminal law around landlord harassment is different. It usually requires some kind of physical threat or physical force, whereas the harassment in a housing context is more about, we'll get to some examples, but it's more about the relationship as landlord-tenant. Also, if you're subletting or if you have a roommate, your roommate or the person you're renting from can also harass you in this way, right? Hopefully not many people have experienced that, but it is common. So I will just say one more thing about this legal definition. It can make it difficult to enforce your rights. I don't want to mislead anybody to make you think that just because there's clear harassment that it then becomes easy to get a penalty. It's hard to prove legal harassment sometimes, and the court system can be a difficult place to make that fight where you are sharing your trauma and not getting any justice. So that's unfortunate, but we all have to stand up for our rights, and the lawyers of Brooklyn Legal Services Corporation A are here to help when we can. I'll go to the next slide just for some common forms of harassment. The interruption of services. So if your heat gets cut off, your hot water gets cut off. Unwanted buyout. So this is a specific one where if they make you a buyout offer and you say, I want to stay in my home with my family, I don't want to leave, make that refusal in writing. Because as long as your refusal is just verbal, they can keep offering it. But if you make the refusal in writing, then they can't offer again. And if they do, it becomes harassment. Another form of harassment that's common is construction noise going on in different hours of the day, dust and debris from construction. Those can be forms of harassment. Misrepresentations and frivolous lawsuits. So they could take you to housing court for rent that you've already paid, or they could try to tell you that you have to sign some new document requiring that you give up some rights in your apartment. Don't sign anything like that. Sign your lease. Don't sign anything extra if you can help it without talking to a lawyer, because that could very easily be harassment. And then there are forms of harassment that are breaking the law in other ways, like changing the locks. We call that an illegal lockout. Sorry, I read knock in a comment. Illegal lockout. That is a crime and is also a form of harassment. And overcharging a tenant, which is again a separate illegal activity, but it's also a form of harassment. And I'll just say to Seth, we'll answer some questions in the Q&A later. So those are some basic forms of harassment. And when you think you might be experiencing harassment, it's best to document it. Like I said about heat, right? Write it down, keep a log, take a picture, take a video. We're a one-party state, so you can record some things. You want to be careful with that, not to antagonize people, but record things if there's something going on, and document it just both for your to prove to your landlord what's going on if you need to negotiate, or to prove in court. Sending a letter is another way to document things. Send it certified so that there's a record of when it got sent and received. And then finally, like I said about heat, file complaints. File a complaint with DHCR. They have a harassment portal. That may take, I'm not gonna sugarcoat it. That could take years sometimes for something to happen from that. But if you start, you have to start somewhere. And filing a complaint is an important part of standing up for your rights. Also, if you want to file a lawsuit, you go to housing court, you don't need a lawyer. You can file a harassment lawsuit on your own or with a group of other tenants. But it's always, if you can, reach out to Brooklyn A, reach out to another legal services provider, reach out to your council member, and ask them, what can I do? I'm experiencing harassment, and they will guide you to resources, and we will, if we can, help. So one of the other things, just to pass it off to Kevin, that people frequently experience along with harassment is discrimination and violations of your fair housing rights. So Kevin's going to talk a little bit more about that.
Thanks, Zach. So yes, to continue right on the theme, when it comes to harassment and also discrimination and proving that case, you also always keep in mind that you ultimately have to meet a burden and prove it. So things just procedurally takes time, and it may not move on a time scale that you anticipate, and it may be difficult to gauge or predict how long a certain action may take, but these protections, these laws are there to protect. Something I often like to remind people, especially New Yorkers, is when you live in New York City, we have not only protections from the US government, from the state as well, but there are specific New York City laws that reflect and often mirror the other the state and federal laws. And when we're speaking about discrimination and housing discrimination, it's pretty much similar, and that's pretty much the case in this in housing. So fair housing rights applies to everyone, and essentially fair housing rights protect you against discrimination based on protected classes. And I put that in quotation marks, and I'm going to get into a little bit more details in the next slide, but this includes based off someone's perceived race or identified race, whether someone identify as living with a disability or not, their identity, how they identify with their perceived or actual gender, and citizenship status as well, including your source of income in the particular job you have. And to echo what was said earlier, New York City residents have special laws that protect us on a local city level, and that those laws are set on a city level. You can reach out to your local council member. Also, the New York City Office of Commissioner of Human Rights enforce some of these laws and make these laws as well. And on the state level, the New York State Division of Human Rights as well. If you believe you're experiencing discrimination, you can file a complaint on the city level, the state level, or HUD, the U.S. Department of Housing and Urban Development, which is the federal equivalent of the previous two mentioned agencies. And next slide, please. So essentially, when I mention protected class that falls under the fair housing laws, it goes from, it's based on a particular person's identified class. So if you feel like you're being discriminated because of your race, of your perceived color or creed, your religious observation or your religious beliefs, if someone says like we don't rent or we don't interact certain tenants, the landlord is not able to have preferences when it comes to these protected class. Someone where they're from, their national origins, or whether they're immigrant or not, if someone is a recipient of city FEPs, or how they're going to pay their rent, these are all protected. A landlord doesn't have the flexibility to say that I want to rent to a particular woman or particular men, someone who identify as a woman or someone who identify as a straight male. These are all protected classes that falls under the discrimination laws that you can seek and get redress if you experience in any of these, as well as disability. If someone lives with a certain particular disability or identify and has a particular disability, they are protected as well. Pregnancies, your marital status, whether someone is a single member living with children or not, how your family structure is also protected. And as mentioned earlier, your source of income. And this also includes city programs like FEPS and Section 8. You cannot be discriminated because you're a recipient of any programs or how your rent is being paid. These are, and this is maybe more common than you may think. Also, your occupation. Someone may, if you are a home health aide or an attorney, sometimes they tell you that landlords don't like to rent to attorneys because of the very fact that we are aware of these discrimination and protected class. But even that, even if your income is coming from annuity or alimony or spousal support, these things are all protected and falls under these identified protected classes, as well as if you have children or if you don't have children. And the last one is very important. If you're identifying as a survivor of domestic violence, intimate partner violence, sexual assault, stalking, these are things that are also protected and can't and shouldn't be used against you when you are seeking housing, especially considering the fact that here in the city, we have protection on the local level, the state level, and the federal government. So there are a lot of ways to redress any acts of discrimination that you experience, as well as harassment. But as mentioned earlier, there is a level of proof that you will have to meet in the courts. So it is recommended that you reach out and connect and speak with an attorney in regards to fleshing out your case, realizing what are you experiencing. And the most important thing, I'm going to echo Zach again and say record it. It's very important that you maintain a record. Something that I often remind my clients personally is that sometimes our memory doesn't serve us the best. But if we write it down, that ability of us looking back at something we've written down refreshes our memory. And that is one of the strongest evidence you can have in the court. Next slide, please. Zach, you want to pick up with Know Your Rights, Taking Action?
Yeah, so basically, this goes back to a little bit of what we talked about before, but just in more detail. So, calling 311, and this is true with repairs, this is true with discrimination, this is true with specifically with heat and other forms of harassment. Calling 311 is an important step. It's not the only step, and it doesn't always result in what you think you deserve, right? So it's important to be realistic about these things, but you want to document it through an HPD or a DOB violation in the case of repairs. Also, if you write a letter to your landlord, especially, I'll talk in a second about getting together with other tenants, you write a letter together, that creates a paper trail. that can be used in court. You can also, I always recommend including, mailing it also to your elected representatives, your council members, maybe your congressional representatives, so they know about what's happening in their district. Then, once you've done that, you can also use that as the basis for a lawsuit or a DHCR complaint if you're rent stabilized. And those can result in an order to fix things or in a order reducing your rent. There's also, on this slide, it talks about something called a 7A proceeding down towards the bottom of the slide. Now, this is a very rare type of court case, but it's worth mentioning. And I'll, this will kind of transition us into the last portion, because if you're in a tenant association, if you're able to get the group of other tenants suffering all together, and you can file an HP case, which is what they call a lawsuit for repairs, you also could potentially file a 7A case. If you're interested in knowing more about that, definitely reach out to Brooklyn A, to our attorneys, or you can go to housing court and ask. But the 7A case may actually result in the city taking over the building temporarily while repairs get done. It's very rare that happens, but we definitely want to support tenants who are interested in that. So we will look at that too. We can go to the next slide. And then, this is a little bit of what I mentioned earlier, but just so that we can reiterate, DHCR, Division of Housing and Community Renewal, is the authority over rent stabilized and rent controlled units. If you're not sure if you're rent stabilized, definitely go online and file a request with DHCR. You can ask them to send you information about your rent history. And then if you are rent stabilized, then they can not just give you an order, for example, with harassment, finding that there was harassment, but they can also, if they find that there's decreased services or an interruption to your heat, they can reduce the rent that you owe to your landlord, and they can do it retroactively. So it's a really, really important tool for tenants in rent stabilized apartments. And go to the next slide. Yeah. And so then this gets to the final point here. Taking action on your own. I know that many of the people listening, you're very, brave and have dealt with a lot of, problems on your own, I'm sure, but going together is definitely a way to gain more strength, right? And more support. And especially when you're going up against your landlord who controls so much about your life and your home, it feels good and it is more effective to work with a group when you support each other. The truth is, if you're going through something with your landlord, they may be discriminating against you individually, right? Based on something individual about you. But many times they're also either discriminating against other people in the building, or they're harassing everybody, right? I mean, I've certainly worked in, I've helped organize with tenant leaders in buildings where there is a wide, diverse variety of tenants. Some are families, some are individuals, some are elderly, some are young, some are on certain types of subsidies, some are, make a lot of money or very high income. And they all experience the same issues from the landlord, because sometimes the landlord is just kind of a negligent person, right? Or a corporation, a faraway corporation that doesn't even know that you exist, right? So it's when tenants are able to come together and support each other that you can take even more meaningful action than you can alone. So we can help with that. We have organizers on staff. We also work with local community organizations who will have, again, organizers on staff, connections. So reach out to Brooklyn Legal Services Corporation A, reach out to council members Gutierrez, Nurse, or whoever your council member may be, right? And say, my neighbors and I, we're going through all these problems, and we want to take action. And from there are a lot of possibilities. And you know, I can't remember the exact quote, but you can see here this picture, you know, about how all the fish together can take over you know, the attacking fish. It's kind of a silly image, but it's also a very powerful idea, right? And I have found in my experience as the group representation specialist at Brooklyn A, that when tenants are able to get together, that the victories they win are bigger and can last longer than when people fight as individuals. So I encourage that, and I think we can move on to you know, just here's basic information about Brooklyn A, and I'll pass it off to Sarah to kind of talk about that and coordinate any questions. Thanks.
Thank you so much, Zach and Kevin. That was, I learned a lot, and I hope that you all did too. Again, if you have any questions or things that came up during the presentation, or you think about it afterwards, always feel free to reach out to us at info@bka.org and 718-487-2300. You can sign up for our newsletters, where we post information about these events and other resources at www.bka.org, as well as follow us on social media. And so we'll now turn it over to our question and answer portion of the evening. I know that a couple of questions are in the chat and the question and answer section. We'll get to those, and then if there's more, feel free to put them in the chat, or if you prefer to speak your question verbally, you can go to the little hand button under the participants tab, and we can unmute you. So we have someone who asked a question, someone that is a renter in a 6-unit building. They have heat through electricity, and they pay for it, not their landlord. The apartment is poorly insulated, causing the heat not to work. What are their options as it gets very cold in their apartment, down to 50 degrees?
So I'll talk about that since I talked about heat. So unfortunately, as far as the heat law goes, there's not a very clear remedy there. Remedy just meaning something you can do. Because it says you have heat through your electricity and you pay for it yourself. And so that's kind of the line that splits off with some of the heat season things. However, the being poorly insulated could be an issue in itself. What I would suggest, again, is if you're able to get a temperature, like a thermometer, that can register what the actual temperature is. So, you know, I don't want to assume, but it seems like maybe if you have electric heat and you have a thermostat, but you're putting it up to, say, 60, and then you're saying that it's actually colder than that because, you know, for whatever reason, the insulation, document that. And then also you can call 311 and have them come and measure that. It's a gray area, so I don't want to oversell it, but it's possible that you could get a violation for lack of insulation and pursue that. Otherwise, you may not be able to get the law to force your landlord to do something, but you could write them a letter to document the issue and formally request that the insulation be fixed, and that would be a step in the right direction.
Great, thank you so much. Okay, if you're living in a legal basement, do you have the same rights around heat, fair housing, around tenant harassment that you're outlining in this presentation?
So yes, and it's difficult to enforce because if it depends, so illegal basement can actually mean a couple different things. Gerardo, I'm not sure exactly your situation. We don't have to discuss it. But in general, so if it's just illegal because it's kind of the type of basement that can't be registered or it's not maintained, like it doesn't have a certificate of occupancy, then you first of all, you absolutely have all these rights and you should be able to enforce them through court, through 311, things like that. If you're in an illegal basement that's illegal because it lacks proper like ingress or egress, so that it's like basically unsafe, then you should, I have to say first and foremost, you should consider, if I know it's difficult to move, but those safety concerns are very real. And if you call 311 to check on your heat, for example, and they find that it's not fire safe, that they may issue a violation for that as well, around fire safety. So with your basement apartment, you do have the same rights, but enforcing them can be difficult because if it's an unsafe apartment already, then HPD or another agency may basically require either that they do construction in the apartment or that you move.
Great, thank you so much. Is knocking on an apartment door and asking for rent a type of harassment?
It can certainly feel that way. I know that there are many situations where that is a form of harassment, right? It's a form of the landlord getting in your face. However, it's not in it just by itself. It's not illegal. The landlord is allowed to request that you pay, that they can come in person unless you specifically request otherwise. And it also depends on the time of day. If they're coming at night, like in the middle of the night, or even, just outside of normal business hours, then that leans towards harassment for sure. And I think that if you say in writing that you only want to communicate with them in writing and by mail, then they should honor that as well.
Okay. Can a tenant be charged for a lease renewal?
Not basically, not for the lease renewal itself, but you can have a rent increase. So that's, in a way, that's a kind of a charge, right? But they can't say that you have to pay again for your lease renewal necessarily.
Like
if
there
you
wouldn't
had
be like
some-
a fee, like a
yeah,
normal
you're not like, you've
application.
already done your application fee and things like that. So for rent stabilized tenants, absolutely not. For a not rent stabilized tenant, there may be some gray area in there. I would talk to a lawyer specifically about your situation, but in general, no, they should not be charging you a fee for a lease renewal.
And Zach, how can folks find out about what are allowable increases in their rent?
Great question, Sarah. You go to the Rent Guideline Board website. Again, they'll put out every year allowable increases for a certain time period. And if it's confusing, if you have any questions about it, whether it's on your lease, reach out to this information here, reach out to Brooklyn A, because it can be hard to read even if you look it up online and read it yourself. It can be confusing. So feel free to reach out.
Yeah. Okay, is it harassment when the landlord refuses to receive the tenant's rent checks or refuses to provide a legal address to send the rent check?
It could be. People make fun of lawyers for always saying it depends, right? But that could be Harrison, that could be harassment. They should give you the information so that you pay your rent. If they're refusing to receive the rent checks, sometimes that's part of an overall strategy around eviction. to try to like take the first steps towards eviction. And if it's frivolous, if the lawsuit against the tenant is frivolous, then that is definitely harassment. So refusing to receive the rent check is not automatically harassment. But if it becomes part of a legal strategy to get the tenant out, then that probably becomes harassment.
Okay, we have someone on who's a landlord, and the tenant is off for a few months. It's getting cold and I'm reaching out to her constantly about the situation. She lost her job and she's able to get help. I told her I'll pay to put it on. She'll have to sign a document that she'll repay me. That's not what she wants, or she doesn't want that. I can't allow my pipes to burst. Please help. So it sounds like the tenant is
The heat is, yeah.
leaving the heat on.
So, Faye, I see that question. I'm sorry that your tenant is dealing with that, and that your building sounds like also could be at risk. The pipes bursting is not something anybody wants, right? So, Brooklyn A work in our preserving affordable housing unit. Specifically, we primarily work with tenants to help with issues. But in a situation like this, you may be able to reach out to the utility company and ask about some kind of payment plan or some kind of like emergency alternative assistance from them, because ultimately the health of the whole building may depend on the heat being on. So that does a responsibility of the owner of the building. I have to be kind of careful with what I say there, but yeah.
Thank you. Okay, we have a question from Nikki talking about pre-war buildings that are notorious for thin walls and severe lack of insulation. You can smell what neighbors are cooking. And they live in a 10-unit HDFC building where there's a number of neighbors who smoke a large portion of the day, smoke and vapors that come into their apartment. Sounds like Nikki has reached out to the landlord, and the landlord hasn't responded to the letters in the last 6 years. They would like to hold the landlord responsible for not allowing healthy and peaceful habitability in their apartment, which has caused some health issues. Their doctors have written letters on their behalf. They were told that they weren't welcome in their building in 2000 when they moved in. And they see the landlords allowing them to be affected by the smoke coming in by others as a form of harassment. Any advice in this situation?
Well, first of all, Nikki, can I just say I'm sorry that you're dealing with that. That's it's so difficult to feel that level of, unsafe, unhealthy in your home. And when it's something that it's not even a switch, like the heat that your landlord can turn on and off, right? It's someone else's behavior. That's really difficult. And I work with many clients who unfortunately face similar situations. You can, I can already tell by the language you're using, your rights inside out, and you know all this stuff, and you can file a lawsuit against the landlord on the basis of habitability and harassment. Failing to stop something can be considered a habitability issue, failing to stop something that's dangerous. However, I would say the smoke, like it's difficult for a landlord to take action based on smoking. So I just have to say that's very true. The other option that you might have is to put in a reasonable, it sounds like you've already done this with written letters from doctors, but reasonable accommodation requests, maybe relocation to another place that the landlord owns. So yeah, there's not a straightforward way to make your landlord take action on that, but definitely a reasonable accommodation request sounds like maybe you've already tried that, but that's a recommendation.
Thank you for that answer. I'm just gonna stop share. Okay. Someone is offering, could Nikki use constructive eviction?
So it's a little bit, so the situation, you could potentially argue constructive eviction. It's maybe more straightforward to argue, this is again like kind of a legalese, but to argue that it's a habitability violation. The issue, the challenge actually comes in with the smoking itself, just in that courts, again, I have to be careful because we represent tenants, and ultimately what you would be seeking to do is to have the landlord take action against a tenant. But I will say that in general, tenants who are smokers, it's difficult for landlords to take action against them. Just courts are really reluctant to penalize someone for that. I don't know how to better say it than that, but it's just tricky. But yeah, it could be constructive eviction, it could be habitability. It's just a difficult right to enforce. It's really, and I want to focus more on Nikki's health, which is where the request for a reasonable accommodation comes in.
Great. Thank you so much. I'm going to do a quick check on our Facebook to make sure that there's no questions there. But we're coming to the end of our time. And so just any final questions? I think we probably have time for maybe one more. There's a request for a webinar about landlord rights. I don't know. What do you think about that, Zach?
Well, so in preserving affordable housing, which is what Kevin and I do, that is not the type of expertise that we have. I would say, so there may be other better suited organizations for that.
Yeah, and I will also say that we our consumer and economic advocacy program does work with homeowners, which are often small landlords. And so we can provide help specifically on foreclosure prevention, helping to get loan modifications, and other services for homeowners and, again, small landlords. But we wouldn't help with, like, let's say evicting a tenant, because that would be in conflict with the other work that we do in preserving affordable housing and just, in conflict with our organization's mission. Even though I understand it's a challenge that everyone faces. Okay, great. So I am not seeing any questions on our Facebook. Okay. Linda, I'm seeing your question. Yes, we did answer about if the landlord could charge you for the renewal of the lease. Zach had said that they can't charge you any like additional fees or anything like that. They can potentially have a rental increase, but there should be no charge or fee on the lease renewal itself. And if you want to hear Zach's more eloquent answer to that, you can review the recording. Okay, and I'm seeing Mr. Henry raising his hand. So Mr. Henry, if you have a question, I will unmute you. Hang on one sec. Okay. Hi, Mr. Henry.
Hi, good evening.
Good evening.
I want to ask one of the attorneys to explain, and I think it's very important for tenants to understand what the warranty of habitability means to a rent stabilized, rent controlled, or fair market person. I think that is not talked about enough, and it's the basis for many of the complaints. The housing is not suitable for human habitation.
Thanks, Bill. This is one of the leading tenant advocates, tenant voicers, tenant leaders in Brooklyn. And we're really grateful to be able to work with him. I'll just say I know it's 7, and so we're running a little bit out of time, but I want to echo what Mr. Henry said. And maybe that's something for another webinar, another training. The warranty of habitability, I'll just say this much: everyone has a right. Right. So in New York law, it's written down specifically, you have a right to a home that's safe to live in, right? Is habitable. And so what that means is that if there's an issue with your housing, even if you're not rent stabilized or anything, that you potentially might owe less rent, right? I just not an easier way to say it. You might not owe all of the rent that they normally would be able to charge. Only a court can decide how much less. That's a difficult thing to say, right? But if you think that you might have a habitability complaint, talk to a lawyer, reach out to us, because we can advise you on your potential options. All right. And with that, I think it's 7. So I think we probably have to wrap up.
Great. Thank you so much. And yes, thank you, Mr. Henry, for joining us and for all your advocacy. All right. Well, thank you, everyone. This was great. It sounds like there's some more topics for us to cover soon. And grateful for you all attending, taking time out of your evenings. We hope that you stay well and warm. And that, feel free to reach out to us if anything comes up. So thanks again to Zach and Kevin. Thank you to Councilmember Gutierrez and Nurse. And we will see you all soon. Good night.
Thanks, everyone. Bye.